Hi, good afternoon, everybody. My name is Anthony Alex. Welcome to our webinar series on the do's and don'ts and the musts for members of the internal committee under the Prevention of Sexual Harassment Law of 2013. This is the second episode of the 5 series webinars that we are running for members of the internal committee. This one is focused on conciliation. You may all remember, some of you may remember from the last session, those of you who attended the first session, was focused really more about the basics of an IC, the constitution and the powers and so on and so forth. Today's is focused exclusively on conciliation, a tool that the law has provided every member of the IC, but not many use it effectively. Before we dive into the sort of session on conciliation, I just wanted to remind all of you about our webinar calendar. This is the second session that, as I mentioned earlier, the session on 5th September at 3 p.m. This is the second session that we're holding on the conciliation process. The next one will be on 18th October at 3 p.m., which is on inquiry and investigation. This is the first of 2 parts, which is going to focus on inquiry and investigation. The second part of the inquiry and investigation workshop or webinar will actually be on 15th November. And thereafter, a very critical component of being a member of the internal committee, which is order writing, documentation, etc. That is going to be in our sort of final session, which is on December 13th, again at 3 p.m. Now, bear with us. Sometimes the dates do move around a little bit, although broadly these dates are cast in stone. But in the event we are forced to, for a variety of reasons, to move the dates by a day or 2 here and there, you will, of course, be notified by email. For those of you who have signed up, you will be notified by email as to whether the dates have changed or whether they remain the same. You will get a reminder on the day of the webinar and a few days before the webinar. So without further ado, I'm going to dive straight into our session on conciliation. We're going to focus on today's session on conciliation processes and the process and best practices. Please, as you know, typically what we do is we finish the entire session. That's for about 25 to 30 minutes. Thereafter, we'll go through all the questions. Feel free to leave your questions in the box that you'll find on your chat screen, which is only for questions. So do leave your questions there, and I'm going to pick up as many of the questions that I can during the course of, once I've completed the session, and I'd be happy to answer as many questions as possible within the time that we have. So we're going to focus, as I said, on the process and the best practices. Now, what's very, very interesting about conciliation is that it is a wonderful tool in the armory of an IC member or a committee as a whole, because it provides the committee an opportunity to settle matters without going through the full inquiry route. So basically, what the POSH Law 2013 provides is two options. One is the option to settle a matter through conciliation, and the other is the full-blown inquiry process, right? So today we're going to focus on what are the do's and don'ts around settling a matter through conciliation, and what are the different ways in which we can achieve that, right? So what is conciliation? I mean, if you take a look at the dictionary meaning of conciliation, essentially, I mean, the legal sort of meaning really is one that is focused on settling disputes in an amicable manner through extrajudicial means, essentially meaning that you don't, without having to resort to court. Conciliation means bringing 2 opposing sides together to reach a compromise in an attempt to avoid taking a case to trial. So most legal jurisdictions, including India, provide for conciliation as an option. The 2 opposing parties have the option to settle a matter through conciliation without having to go in for a full-blown trial. What the framers of the 2013 POSH law have done is provided that option even for cases of sexual harassment that go before the internal committee. The internal committee, as you know, has powers of a civil court, so is therefore on par with a civil court in that sense. Therefore, when you file a complaint, if a complaint is filed with the internal committee of a company constituted legally under the POSH Law 2013, then one of the two options that are available to settle the matter is conciliation. What is really the objective? The objective is potentially in lower intensity cases, the IC can actually get both parties across the table. Sometimes it's a misunderstanding. Sometimes all the complainant wants is to quickly resolve the matter without really going through the full-blown trial process or the inquiry process, as it's known as under the 2013 law. So it's primarily for that reason that the law has provided for conciliation as a way of settling disputes or settling a complaint of sexual harassment. So that's really the objective. Now let's kind of dive a little deeper into how that works. Two things that are very important to bear in mind is, one, conciliation can only be at the option of the aggrieved woman. So only if the complainant is agreeable to settling a matter through conciliation or settling the complaint through conciliation can the conciliation process be initiated, right? Of course, as you know, in a mediation or a conciliation kind of scenario, it requires both parties to agree to it. So the respondent naturally has to agree to a conciliation process in order for it to move forward. If the respondent is not agreeable to it, then naturally the conciliation process will fall. But right up front, right at the beginning, everyone must remember that the conciliation process can only be initiated at the option of the aggrieved one. The second important point to remember is that the conciliation option is on the table as long as the inquiry process or the investigation process hasn't started, right? So that's how the law looks at it. Once the inquiry process starts and it's become a full-blown inquiry, then conciliation is not really an option. One has to go in for the full inquiry process, which is why it's important for members of the IC to offer the option of conciliation to a complainant when the complaint comes in. Now we'll just go into a little more detail as to how that happens, but it is important to know that conciliation can only be initiated by the aggrieved woman, and only if she's interested in or wants to move ahead through the IC process in the form of conciliation can that happen. So in other words, what a lot of the verbiage or the terminology that a lot of people use is informal process and the formal process. You may, as IC members, have also heard that. The informal process is what we call the conciliation process. The formal process is what the law provides for as the full-blown inquiry process. So that's sort of the two parts or how it breaks down under the law, so to speak. Okay, so when does a conciliation start? Now, while the law says that it has to be initiated prior to commencement of the inquiry, it can happen at a number of different stages, and legal experts are divided on this. But what everybody is unanimous about is the fact that the conciliation process must be initiated before the inquiry commences. So the law is very clear on that aspect. Now, if you are the view typically quite a few experts seem to take is that the process can commence once the complaint has come in and the complaint has been forwarded to the respondent. The respondent has sort of reviewed it and sent back their response to the IC. So two parts of how the entire IC process works has been kicked off. The complaint has come in, complaint has gone to the respondent, respondents reviewed the complaint and provided his response back to the IC and or the complainant, right? So it's at that point of time that before the full-blown inquiry process starts, that the IC will have a conversation with the complainant and explain how conciliation works and ask her whether she is comfortable with or interested in moving forward with the conciliation process or whether she'd like a full-blown inquiry. Should the complainant respond in the affirmative and say that, yes, I am interested in moving forward with conciliation, then the IC will have a conversation with the respondent and then explain to the respondent how the conciliation process works and says that this is what the complainant has asked for. If you're interested, we can try and resolve this matter through conciliation. Now, typically in what we call lower intensity offenses, conciliation is the best way to resolve a matter because it's quick, it's speedy, and you can get two people across the table and close the matter. So, coming back to the process, the first step towards conciliation is to ask whether the complainant is interested or would like to explore the option of conciliation. If she says yes, we move ahead, ask the respondent. If he says yes, then the matter moves into conciliation. So that's what you're seeing on your screen. The IC reviews the response that has come in from the respondent, and then you have to outline the right of conciliation to the complainant. If she says yes, then explain how conciliation works to the respondent as well, and then initiate conciliation if applicable. Now remember, there may be a scenario where the respondent might not actually want conciliation. There are some instances in which the respondent says, look, I'm not interested in conciliation because I'd rather go in for a full-blown inquiry and whatever. Sometimes it's because they want to clear their name or what have you, because they feel that the complaint has no merit. It could be any number of those things. So it is important to bear in mind that conciliation, by its very term, indicates that both parties have to be okay with it, but the conciliation has to be initiated at the request of the complainant. So that's the little nuance that all of you need to be familiar with. Thereafter, the conciliation settlement. So assuming both parties come to an agreement and they say, you know what, this is what happened. The complainant says, this is what I felt offended by. The respondent either apologizes or whatever it is, the facts of this case are, both the parties agree that, okay, fine, we agree that we'll settle this particular complaint on the following terms. The IC records the terms. That's what it's called, recording the conciliation settlement. So the terms are recorded by the IC, signed by the complainant, signed by the respondent, and signed by the members of the IC. And you have commenced and closed the IC conciliation process. It's important to remember in this that the IC is not acting as a, let's say, in a judicial capacity as it would if it were an inquiry. The IC is actually acting more in the capacity of a mediator, as somebody who's trying to get two parties to see each other's point of view, get them to come to a middle ground and assist in that process. So that's really what the conciliation process is, and that's the role of the IC. So there's a difference between what an IC does when it is assisting in a conciliation and what it does or what its role is when it's assisting or when it's actually looking into a matter through a full-blown inquiry. Now, the last bit that's very important to remember is the IC's job doesn't end by just signing the conciliation terms and closing the matter. The IC thereafter has to follow up. The IC has to follow up and assist in the implementation and monitoring of the conciliation settlement. What does that mean? So let's say the conciliation, the parties agree that the complainant was right in feeling offended, she felt sexually harassed, and the respondent has apologized and has said that you will get a written, part of the terms is that the respondent has said, I will give a written apology within 7 days from the date of the conciliation settlement. Now, if the IC has to follow up and ensure that all the sort of I's are dotted and T's crossed to ensure that that particular matter is closed. So if there is something that has to be obtained from the respondent, then IC needs to ensure that that is obtained, and then only the matter is considered as closed. So that's what it's meant by assisting implementation and monitoring of conciliation settlement. We have to ensure that the conciliation settlement has reached its logical conclusion. There is another aspect to this as well. What happens is that sometimes the conciliation may have closed, that matter may have closed, but you may find that the respondent is continuing to engage in the behavior that brought about the complaint and consequently the conciliation order in the first place. In that situation, the IC will again have to look into the matter, and it may well become a full-blown inquiry if that is the case. But more on that, we'll come to that later. So that's sort of broadly how the conciliation process works. Now, these are some of the things that an IC member needs to bear in mind when they are facilitating conciliation, right? So these are the key points. So as I've already mentioned, it can only be at the behest of the aggrieved woman. It cannot be at the behest of the respondent or even the IC for that matter. So the critical person in the entire conciliation process is the aggrieved woman or the complainant, right? She needs to be comfortable with the conciliation process, and she needs to feel that that is the solution that she is seeking. And if the respondent then agrees, then they move ahead. So it has to be at the behest of the aggrieved woman. Secondly, and very, very important and very critical, is that money cannot be the basis of conciliation. So, for example, a settlement terms that may be arrived at between two parties cannot, for example, state that the respondent has apologized and has agreed to pay the complainant, say, ₹1,00,000 or whatever it is that amount is that is considered to be appropriate or that the two parties have agreed to. That cannot happen in a conciliation. Why is that? Because the lawmakers did not want a situation where conciliation is used more as a tool to close matters by paying cash or compensation. The law does provide for payment of compensation, but that can only be at the discretion of the IC, and that too in a full-blown inquiry process. In a conciliation, money cannot change hands. Money cannot be the basis of any settlement terms that are arrived at. So this is a very, very key aspect of the law, something that all of you must bear in mind when you are facilitating closure of a matter through conciliation. Now, some of the sort of other aspects that one needs to bear in mind. It's important to sort of adopt a very calm and conversational manner, because it is important to get both parties to be comfortable. Both the complainant and the respondent have to be comfortable in the setting and with the fact that we are looking at a conciliation scenario. It's important that the IC should not sort of pressurize either party into a conciliation settlement because it feels it's the best way forward. Rather, it should facilitate it. So both parties should feel that this is exactly what they both should feel a sense of wanting to close or take the matter forward through conciliation. So the fourth point, encourage conversation between parties, very, very critical. So if the IC members themselves are calm and conversational, you will find that conversation happens automatically. The process might vary depending on the IC members and the style they adopt. You may first have a conversation with the complainant, then have a separate conversation with the respondent, and try and see if the two of them are close to sort of meeting, on a common ground. If required, and if the IC believes appropriate, because sometimes it can be the complaint can actually be the underlying tension between the parties may not facilitate a conversation between parties, but ideally, you should ensure that the two parties sit across the table with you after you've had a conversation with each of them, and try and encourage a conversation between the two sets of people. Here, it is very, very important to note that the IC must underline the confidentiality requirements. What is that? The law, the Prevention of Sexual Harassment law, clearly says that all matters that come before the IC have to be kept confidential. Both parties need to know that there is a legal obligation for both of them to keep whatever happens, transpires, settlement terms, everything. They are required to keep it confidential. So it is important that both the complainant and the respondent are made aware that the settlement terms of the IC must be kept confidential. So that's something that should be stressed upon at the time of conducting the sort of settlement hearing. We'll come to this in a little more detail, but the settlement terms essentially has a binding legal value, right? So once you close a matter through conciliation, then it's treated as an order of the IC, and therefore that matter is closed forever. Again, we'll sort of dive into that in the next slide. What this really means is, hang on, give me a second, my slide isn't changing. Yeah. So here's the legal enforceability of the settlement. What it really means is that if the parties agree to settlement terms, then a binding order is passed by the IC. So what it says is that if the complainant, respondent, they both say, yes, we agree, these are the terms, and this is how it's going to happen, then the IC passes a binding order, which will be binding on both parties. In the event that, let's say, the order requires either party, mostly it is the respondent who needs to do something under that conciliation terms. If they're required to say, let's say, give an apology within 7 days or 14 days, or give something in writing, or whatever it is that they've agreed to, barring sort of money or sort of money exchanging hands, then the complainant can actually go back to the IC and request for a full-blown inquiry, which means then that the conciliation is off the table. So that's the only exception. Otherwise, once the conciliation terms are passed, it's cast in stone. It closes the case forever. You cannot, neither party can reopen that case, right? The only exception is that if either party is required to do something under the order and they don't comply with that requirement within the time frame that is specified in the order, then the complainant can go back to the IC and sort of request for a full-blown inquiry, right? So that's basically how the IC process works. If both parties abide by the terms, particularly the respondent, because mostly in conciliation terms, a respondent would have to do something in terms of either an apology or anything else that is agreed to between the parties that would be required to be done by the respondent. And if the respondent so agrees and abides by the terms, then that matter is closed forever. This is very, very important for all of you to know and understand. That matter cannot be reopened on that particular issue. Now, in the event the respondent commits a similar act again, either with the same complainant or with another person, then that is treated as a fresh cause of action, which means it allows the complainant to, it allows whoever is aggrieved to go back to the IC with a fresh complaint, and this time they may not obviously opt for conciliation, but that's treated as a new complaint. For whatever has happened, the incident that has happened, under which the settlement terms have been arrived at, that is considered to be closed once the IC has recorded the order or the settlement terms and the parties have abided by it. That case is closed and cannot be ever reopened again. So that's sort of how the conciliation process works. Now, some of the red flags that IC members need to bear in mind are as follows. One is if there's an undue haste or reluctance on part of the aggrieved woman to reconcile. So, sometimes some of this is really a lot of gut instinct, right? As humans, we all have a gut instinct about whether something is right or wrong. And when you find that there is either undue haste, that means the complainant is in a tearing hurry to say, no, I want to close this, I want to close this, I want to get on with my life, I want to close this case and move on. Or if they are dragging their feet a lot, it could mean that there is something underlying which needs to be probed further. For example, it could be external pressure from the employer, a senior member of the management saying, listen, I'd like you to close this through conciliation if you value your sort of role in the organization, or if you want to continue working for us, or what have you. Or it could be, supervisors, it could be other peer pressure, what have you. Now, if that is the case, then the members of the IC have a very delicate task at hand. You basically have to find out what is the issue that is bothering the complainant and who are the people pressurizing the complainant. You have to get that information out in a way that at the same time, by reassuring the complainant that you have the power and authority to ensure that no victimization or retaliation will happen against her in the event she does not reconcile the matter. So it's very important for IC members to also probe a little further. If you feel that the complainant is coming under extreme pressure to settle, it could also be that the two parties have had a history of issues. It could also be that another red flag could well be that it is a consensual relationship that has gone sour. We don't know. It could be 100 reasons. So it's the bottom line that I want to leave with all of you is, remember the cardinal rule. If you feel that something is not right, then probe further. Always probe further to ensure that you are getting exactly what you are getting to the bottom of the matter. Sometimes complainants are under tremendous pressure to settle and they may not want to settle. So these are all the things that a good IC, a well-trained IC, and an IC that's not in a tearing hurry to close the matter, but wants to actually do justice, will do. You have to make sure that you get to the bottom of the matter before you close the matter or before you push through the settlement terms. So these are some of the red flags that you must bear in mind as members of the IC, so that this is sort of, these are some of the things that mean that you have to dive a little deeper before you close out on that particular case. Now, so in a nutshell, what does this mean for, I'm just trying to sum up essentially what the entire conciliation process is. For an IC member, it is critical to adopt a neutral stand. Now, as an IC member, if you are, whether you are in a conciliation process or whether you are conducting a full-blown inquiry, at all points of time, it is very important to ensure to keep your body language neutral. Both the parties should feel that your only interest is in settling the matter amicably between the parties, and that you don't have any other vested interest, or you're not supporting one party against the other. That is very, very critical. So adopting a neutral stand is very, very important. It's also important to give both parties a fair hearing, right? So when you hear the complainant out the first time or the second time, or how many other times she needs to have a conversation, and likewise for the respondent, ensure that you give them both a fair chance to give their side of the hearing. Do not have any prejudged issues, do not have biases. Try and keep an open mind. And sometimes this is hard in a company because you work with some of these people, right? You may have worked with either the complainant or the respondent in the past, or you may know them very well. Then it becomes very difficult to actually stay neutral and unbiased, but that is critical. You have to actually stay neutral, unbiased, and give both parties an opportunity of being heard. Thereafter, once you've heard both parties, you have to get to the bottom of the issue. Identify the core issue. What is it that the complainant felt aggrieved about? What is it that the respondent sort of did? Identify the issue and then facilitate a settlement between the parties. So once you get to the bottom of the issue, let's say issue A is that the respondent sort of brushed past me in the hallway, or while I was in the cafeteria, or while I was in the cooler area, what have you. That if that's the only issue, then that zero in on that, and then have a conversation between the parties to sort of get them both on the same page as to what really happened. Sometimes, even though the respondent might say that, look, I never did this, but I'm ready to apologize and move on, you could consider that and see if that is a way to kind of close the matter. Although ideally, it's best that you get the party to also agree that what they had committed, the offense that they've been accused of doing, they agree to it, because then they realize the importance, they realize the significance, and they realize that if I've done this, I should not be doing it again, if nothing else, because of the legal consequences, right? So it's an opportunity for the IC also to sort of instill sort of the right message to both parties, particularly the respondent, to say that while this is a conciliation, you need to ensure that this doesn't happen again, and that we'll close this with an apology or what have you. Most critically, sometimes IC members are silent when conciliation involving two parties, particularly a very senior party, tends to degenerate into or descend into a squabble. Sometimes it can be verbal abuse, sometimes even physical abuse. The parties, either the complainant or the respondent, might end up sort of pushing or slapping each other because the matters have got so heated. Now, this may happen 1 in 100 or 1 in 1,000 times. But at all times, as the IC member, you have to stay in full control of the situation. So if you believe that the conversation between the two parties is degenerating fast, step in, ensure that you separate the parties and maybe reconvene on another day when the parties are calmer. If the same thing repeats itself, then clearly conciliation is not happening or is off the table, and you may need to then advise both parties that we're going in for a full inquiry because conciliation is not proving to be productive. So that's really the sort of bottom line with respect to conciliation. But very, very important, do not allow either party, particularly the senior party, to browbeat either the other party or the IC. Sometimes you may find that the person who is either the complainant or the respondent is senior to most members on the IC, and they may try to browbeat you even in a conciliation process. Do not allow that to happen, because as members of the IC, you stand above them in that particular scenario, and they do not have a right to browbeat or push or verbally or abuse or threaten any member of the IC. So always remember that when you're conducting a conciliation session. Stay in control, stay calm, and ensure that the matter is well within your control at all points of time. So with that, we come to an end of the conciliation session. Happy to take questions, if any. I'm just going to quickly flip through the questions from the beginning and see if sort of what are the questions that some of you have asked. Thank you all. I can see a fair bit of questions that are coming in. Let me just take them one after the other. Prerna is asking, will the PPT be shared? I'm sorry, Prerna, the PPT won't be shared, but there is the entire webinar is shared. I think my colleague Neil has answered, so therefore you can actually replay the webinar if you'd like. So you can see it as many times as you'd like. So that's there. Sanjay is asking if conciliation to be facilitated by IC only and not by leadership team. Yes, Sanjay, the conciliation can only be facilitated by the IC, particularly if once the complaint has gone to the IC. Now, if it is informal, it's outside, the complainant hasn't even filed a complaint and doesn't want to take it forward, but has just gone to her manager, and the manager, we don't recommend it, but it's been known to happen. And the manager may facilitate a sort of an amicable settlement. But here's the key thing: if the conciliation order or terms have to have, or the settlement terms have to have legal binding value, then it should be facilitated only by the internal committee and nobody else. So do bear that in mind. Only the IC has the power to provide binding terms with respect to that particular complaint, or terms that are binding on both parties. So therefore, we always recommend that any conciliation must be through the IC and not outside of the IC. I hope that's answered your question. So Ruchi is asking, do you need to mention time frame in the order? I'm not sure what you mean by time frame. The law provides for 90 days to sort of conclude the entire process, but hasn't really provided any time frame for closing out a conciliation matter, though typically what we would say is if within 7 to 10 or maximum 15 days, if a matter hasn't been resolved, typically most matters of conciliation tend to get resolved within 3, 4, 5 days. But if it's not got resolved within 10 or 15 days, then that's a red flag for you as an IC. You will probably need to take it as a full-blown inquiry. So Sanjay is asking, when conciliation process is ongoing, then if respondent has to be put under suspension? No, not at all, unless you believe the whole conciliation process is one where it has to be amicable. Now, if you put the respondent, if you suspend the respondent, then chances are that arriving at a conciliation is going to be very, very difficult. So unless the IC has valid reasons to believe that the respondent is browbeating or bullying the complainant, in which case, of course, it can request or it can order the respondent to sort of, I would still not use the word suspension. I would probably ask the respondent to either work from home or any other option that can be explored barring suspension. Suspension is a very, very serious step, particularly in the context of conciliation or as an interim relief. So I wouldn't recommend that. Rama is asking where to file returns for Pune region. Rama, I don't have that off the cuff, but I'm sure my colleagues can. If you write to us, we can share that information with you separately. If within 24 hours, Sanjay is asking, harassment happens between the same parties, then also it's a new case. Yes, Sanjay. If while the conciliation talks are ongoing, if a separate incident happens, then it's a new cause of action, and the complainant has grounds to file a fresh complaint as well. Samadatta is asking, what is the quorum of IC in conciliation process? The law doesn't clearly distinguish between quorum for IC process and inquiry process. It says quorum is 3. We'd always, and the presiding officer's presence is mandatory. I would always recommend that follow the minimum quorum stipulated in the law in case of sort of a conciliation matter as well. In case of repeated offense, does conciliation option is the conciliation option available to the respondent? Well, the conciliation option is never available to the respondent. It's the complainant's choice. The respondent can choose to participate or not, as we have discussed earlier. Neha is asking, do we have to file a conciliation settlement deed? You don't have to file it with the government or anywhere. It is for the IC's own records, but settlement terms are documented, signed by the complainant and the respondent, and by the members of the IC who participate. Surabhi Sharma is asking, can the IC take an action if complainant goes to file a criminal complaint after a settlement? Well, Surabhi, here's the thing. The conciliation settles the matter from a civil perspective, right? The IC is a civil court. And so a conciliation, when I had said that the conciliation terms mean that case is closed, it is closed as far as civil remedies are concerned. But as you know, the IPC has also made sexual harassment of a woman a criminal offense as well. And therefore, if the complainant or the aggrieved woman always has the choice to file both the civil remedy with the internal committee and file an FIR with the police. The IC cannot and should not take any action if the complainant files a criminal complaint. That's the right that she has under a separate criminal law. So there's no way to sort of, you cannot discourage that. That if she has, it's her choice to go ahead with that if she wants to. Kriti is asking, is it the responsibility of IC to implement the conciliation terms or the responsibility of the top management? IC would require support. So Kriti, the answer to your question is that the IC has to, the conciliation terms will typically be implemented by the management, but it's the responsibility of the IC to follow up and ensure that they have done so. So if they need to remind the management that this needs to be done, then it is their job to do so. Of course, at the end of the day, if it does not get done, as I mentioned earlier, the complainant has a right to initiate fresh proceedings as a full-blown inquiry. Ramana Kumar is asking, what is the role of the external member in the IC? Well, the external member's role is always critical, whether it's the IC, whether it's the inquiry process or whether it's the conciliation process. The reason is twofold. One is that the external member brings expertise to the table. They know, they have handled multiple cases of conciliation or inquiries in the past. They are best suited to advise you on the legalities. The second is that they also, because they're not a part of your organization, they're also seen as unbiased. So having them as a part of your quorum, having them as a part of your meetings also gives comfort to both parties that, look, there is a third party, there's an external member who is unbiased and who's going to ensure that, you know, the proceedings, their conciliation and is handled in a proper and unbiased manner. So we always recommend, the law doesn't mandate the presence of the external member as a part of the quorum, but we always strongly recommend that you have your external member participate. So Sandhya Advani is asking, what is to be done if the complaint is not specific? Can IC return complaint and ask for it to be rectified before forwarding to respondent? Absolutely, Sandhya. In the event that the complaint is not specific and there are lots of gaps, there are lots of, there's not enough, substance, but there appears to be a case, or even if there doesn't appear to be a case, it doesn't matter. The IC needs to have a conversation with the complainant, explain to the complainant that these are the areas that the complainant needs to fill up in the complaint so that the complaint is comprehensive. Once that's done, they can send it back to the IC for the IC to process and send it forward to the respondent. One thing to bear in mind is to ensure that all of this is happening such that there is a 90-day period within which a complainant needs to file the complaint. It's a technical requirement under law. Try and ensure that it is within that 90-day period, or the IC has the option to extend it by another 3 months. So if that happens, the IC can exercise its option to extend it by 3 more months. But as far as possible, please ensure that the complaint is filed properly, written, everything within the statutory timelines or time limits. Vivek Chauhan is asking, can you recommend who will be the ideal external IC member? Well, look, Vivek, the law prescribes a few things. It prescribes somebody familiar with issues of sexual harassment. It says somebody who's associated with an NGO. In my mind, though, I feel that a legal background is helpful. You can put that down to my bias because I'm a lawyer, but I honestly believe that this is a quasi-judicial function. There are many aspects that need to be taken into account, including even things like conciliation, mediation, if you're in a full-blown inquiry, evidence appreciation, order writing, all of those things. Somebody with legal training or a lawyer is best equipped to help you. So if I were to sum it up in sentences, I would say that a lawyer, but they have to have sufficient expertise and experience in this practice. Otherwise, they will not fulfill the legal criteria laid down by law. So they have to have experience or expertise in this area. That's the critical aspect that the law mandates, right? So that's I hope that answers your question. Prerna is asking, is there a preferred time frame? I think I've already answered this. Try and complete it within 3, 4, 5 days, a week, 2 weeks tops, no longer. Any longer, then it looks like you're probably in a situation where this is not going to settle through conciliation. Anukriti is asking, if the matter is not between two specific parties, but again someone who's passing sexist and homophobic remarks to multiple people, then can the IC take suo motu action if this behavior is known to them? And will conciliation help with such a problem? Anukriti, unfortunately, the law is very clear. The IC can commence legal proceedings only on the basis of a written complaint by an aggrieved woman in writing. So any of those things, if any sexist remarks are made and that fall within the nature of sexual nature or within the definition of sexual harassment as the law sees it, then she can file a complaint with the IC. And yes, of course, even conciliation can help in that situation. But the initiation must happen by filing a complaint in writing by the aggrieved woman. There's no shortcut. There's no other way to kind of deal with that. Sandhya is asking, does the IC need to maintain hard copies of all records or whether soft copies acceptable? Sandhya, I'd always say keep hard copies. In fact, what we recommend is that keep hard copies of the settlement terms, but also keep soft copies as backup. So either in a hard disk or in the cloud, password protected, where only the IC members have access to it, but you should keep both. Sometimes when a matter goes in appeal to a higher court, they may ask actually for hard copies. They may want to actually see the actual original, and in which case then you'll be left scrambling. So I always recommend that keep the hard copies as well. Don't destroy them. Vidya is asking, during the monitoring of the conciliation process, if the IC finds the respondent continuing the same behavior, you mentioned that the IC can initiate a full-blown inquiry. Does that require the request of the complainant, or can the IC initiate inquiry on its own? If what you're asking is sort of in a little bit of the gray area, but my view is that the IC can initiate inquiry on its own as well. It can actually call the respondent and let the respondent know that they were required under the terms of settlement of the IC to do A, B, C, and X, Y, Z. They haven't done so, and the IC is now taking the original complaint forward in the form of an inquiry. So that's something that we believe the IC has the power to do. So settlement terms need not be shared with the management, right? Prerna is asking, well, typically the IC keeps the settlement terms. You may find that management would like to know what has happened. It is really the if the IC believes that sharing that those terms could lead to leakage or violation of confidentiality, then it can exercise its right and say, listen, we can't share this with you because of confidentiality reasons. So largely we'd say that it's best not to share too much. You may want to share just a brief or a summary or a synopsis explaining to the management that this happened and this has now been resolved. Marshneil is asking, what do we do when both aggrieved and offender are of the same gender, particularly males? Well, Marshneil, the recourse is then not to the POSH law 2013. The recourse will have to be under your own internal code of conduct or what have you. So many companies have actually created a separate sort of committee to deal with these kind of cases, because the internal committee under POSH law can only deal with cases where a woman is aggrieved. So the aggrieved person has to be a woman, or the complainant has to be a woman, because the law clearly is for protection of women from sexual harassment at the workplace. So therefore, it has to be a woman. But this can be dealt with separately under the code of conduct of the company, and maybe it has a disciplinary committee or any other committee that can actually get this. So Raina's asking if there are no witnesses, how do we solve the inquiry? Raina, we will pick that up. We have 2 sessions. The next one and the one following that are both dealing with inquiry and investigation. So we will pick that up in that session. Shreya's asking if the manager happens to facilitate a conciliation, does an IC member have to execute an authority letter for the same? Shreya, look, manager should not facilitate conciliation. The matter must go to the IC, and if you want it to have the legal validity as envisaged under law, then it must go to the IC, and the IC then has to facilitate the conciliation and put down the order terms. So we recommend this in manager trainings, that typically if a complaint comes to you, then the best course of action for a manager is to take it forward and move the matter to the IC. Thank you, Vivek. Thank you for your kind words. Aditya is asking if an organization has a global presence and a complainant is in India but the respondent is in overseas offices, will the law be applicable or IC can initiate proceedings against the complainant? Aditya, we'll cover this in the next 2 sessions, because this session is focused exclusively on conciliation, so I don't want to kind of divert from that. But we will cover this in the next 2 sessions. So please do bring this up when we have our next 2 webinars in October and in November. Sanjay is asking if conciliation has to be done between an internal employee and external vendor. Can be done, very much done. So as long as the external vendor is comfortable with the conciliation process. So like I said right at the beginning, you need to ensure that both the complainant and the respondent are okay with conciliation. If they are, then conciliation can be facilitated between an internal employee and an external vendor as well. So that's not a problem. Aditya is asking if an incident occurred overseas. Again, Aditya, will come back to your overseas issue in the inquiry process. I'd love to take this up, but we're kind of running out of time, and also we are focusing our session today only on conciliation, so I don't want to dilute that. But I definitely will we can dive deeper into the overseas question, because it's a nuanced issue and one that comes up very often. So particularly for subsidiaries, Indian subsidiaries of foreign MNCs. So we'll pick that up in the next 2 sessions. Averelia, I'm sorry if I've mispronounced your name. If the complaint is against the IC member, then the IC member must mandatorily step down from the IC. They have no choice; they have to step down. That's following principles of natural justice. So that's the way to deal with that. Swati is asking if the respondent wants to go to the full inquiry rather than conciliation. What is the next process? Swati, the only way to deal with that is full inquiry. So you cannot force a respondent into conciliation. By its very nature, it requires both parties to come together. So if the respondent wants to go to the full inquiry, you have to respect that, and the IC then has to go ahead with the full inquiry. Thank you for your kind words, Anukriti. Thank you, Mashnil. Aina, thank you. Shreya is asking, how can we identify, decide if a case is low profile or serious? Typically, you would be able to know, and we will spend more time on what is a low profile or low intensity case in our next 2 sessions, one of which will also focus on punishments. So I will spend some time in sort of guiding you on that. Thank you all for your kind words. I think we're almost at the end. Pinky is asking, what happens if an IC member is the aggrieved person? Will she be removed from the IC committee? Pinky, yes. They will have to step down from the IC committee only for that matter. So for that matter, they will have to step down, and the other IC members will have to complete the matter. If the aggrieved woman is also the presiding officer, then the organization will need to appoint a new presiding officer, because no IC hearing can ever be heard without the presiding officer's presence, right? So that's sort of mandated by law. All right, it looks like we have come to an end of the session. Thank you all so much for participating. Thank you all so much for your questions. I look forward to seeing you at our next session. We've sort of shared the dates with you already. So please do log in for our next session. The next 2 sessions are critical. They're going to focus on inquiry and investigation. So do join in October and in November for our next 2 sessions. I think the next one is on October 18th. So do join. I look forward to seeing you all then. Thank you for your time, and see you soon. Thank you. Bye-bye.